Hello. Hi. Hi, everybody. It's Tracy B from the Divorce Solutionist. This is Thick of It Thursdays, which is something I do every week, well, most Thursdays. Sometimes my schedule doesn't allow me to, but for the most part, every Thursday at 4 p.m. Eastern Standard Time, I go live on my Facebook business page, my groups, the Divorce Glow Up, and not groups, group, the Divorce Glow Up, and on YouTube, on my YouTube channel, the Divorce Solutionist on YouTube. So I chose to do something a little different this week because I have something very, very, very interesting coming up, and I wanted to actually get the anticipation going. So I don't know how many of you know, but I do run another group aside from the Divorce Glow Up called Pro Se Divorce and Custody. And that group on Facebook, of course, and that group is geared more toward people who are unrepresented or pro se and who are going through or thinking about or have gone through divorce or custody. Um, but actually, in that group, I do talk about child support too. I don't talk about child support a lot, but I do talk about child support in that specific group. So if you are pro se or you know someone who's pro se, that group is growing. It's growing with members, but it's also growing with content. Every week, I try to add something to the files or the guide section or just posts that are very informative. Um, so if you know someone who could benefit, who's self-represented, you have to be self-represented or in between lawyers, because I don't want that group to get bogged down with people who have lawyers and come in and talk about what their lawyers said. Um, no offense, but I want it to be something resourceful for people who choose to, for whatever reason, or they don't choose, they're forced to be unrepresented. I want them to feel comfortable and not feel like they are second class citizens because they don't have an attorney. And again, for whatever reason, they may not have representation. I just want that group to remain um, intact for people who are unrepresented or pro se, which is same thing. So anyway, in that group, though, I spend a lot of time creating helpful resources and tools for the pro se litigants because um, that is my way of giving back. I am Most of my audience knows that I'm very spiritual, and one of the things that I pride myself on is always making myself available to share information, insight, wisdom, resources, tips, leads, whatever I have access to share it with people, especially the people who need it most. So that's why I go in there and I try to create, it's very time consuming, but it's very rewarding. I try to create content, tools, resources for that group particularly. But in the Divorce Glow Up, which is my first baby, it's a mixture of represented and unrepresented parties and those in between. And it's geared more toward people who need not just practical support, but emotional support as well. That's why it's called the Divorce Glow Up, to help people with the mental and the spiritual and the emotional stresses that go along with going through divorce and or custody. So that's the difference between those two groups. And but it's still me. It's the Tracy B in both groups, and my focus is a little different, but my intention is the same: is to help and be of service to people who are going through what my viewers, my audience is going through. So anyway, I brought up the groups because one particular member brought up the fact that she's going through a hearing / trial. Those words are used interchangeably in family court because usually a custody trial, it can be referred to as a hearing in family court. And so I'm going to use those terms interchangeably. But anyway, she mentioned that she has a custody hearing scheduled, and she wanted to know, and she's self-represented, and she wanted to know the practical methods and means to get through that whole process, the whole ordeal, um, from someone like me. So I decided to do a workshop, a 3-part workshop, where I will go through um, trial preparation and trial prep and trial. I was trying to think of another word, but excuse me. I'm looking at my notes. Yeah, I still write everything down. I am so old school, but when I write, it gets embedded in my brain. So that's why I write everything. I write everything. And I wrote down some of the things I'm going to discuss in the workshop. I wanted to spend today, though, talking about the workshop and then talking about some of the services, excuse me, I offer. I'm sorry about that, because that was something else that came up last week. Is someone asked me, "Oh, can you tell me exactly what you do?" And I said, "Oh, it's not clear? Sure, I can tell you that." Okay, I don't know where my book is. Something tells me a little 8-year-old. Here it is. Got a hold of it. Nope, it's right here. Okay. So I'm just going to go through the outline for the workshop today, because the workshop is going to be um, 3 parts. The first part will be totally free, and it's going to go. I'm going to go breeze through all the sections of trial preparation and trial. And when I say breeze, I don't mean like spend a second. I'm going to spend a few minutes talking about each step, each phase, and but the other 2 days will be a more in-depth discussion about each phase of trial prep and trial, for specifically for child custody and divorce. Okay, I'm going to try to mesh those two, and I say try to mesh because divorce is usually divorce trials are usually a little bit more um, varied. You know, they have a little bit. If a divorce goes to trial, first of all, because only maybe 5 or 10% of divorces actually go to trial. Most of them settle. But if it actually goes to trial, then it's usually um, financial experts involved, and actuarials, and forensic accountants and all that stuff. And as opposed to child custody, which usually, if they are experts, it's usually mental health professionals and the like. But it's usually just lay people as witnesses and the parties, and that's usually, what the child custody trials consist of. And yeah, more custody trials do happen than divorce trials. Yes, there are much more cases, child custody cases, that actually go to hearing or trial than divorces do, and part of it is because of money. But the other part of it is because, parties are willing to fight over their kids and who gets custody more so than they're going to fight over who gets, the car or the debt or or the assets. And for whatever reason, that's just my experience anyway. So the what I'm going to talk about on the first day will be, um, I don't know if this is in any particular order, but I'm going to talk about pretrial. Pretrial is usually consists of narrowing down the issues that are going to be presented in the trial, in the hearing. And most judges require you to do a pretrial hearing, a pretrial conference. They call it something different everywhere: settlement conference, pretrial conference, um, whatever it is. But it's usually to serve the same purpose: to iron out the issues, to resolve what you can, to settle what you can, negotiate what you can, and narrow down what the issues that are that are left over, narrowing those down so that the court is aware of what actual issues will be litigated, will be tried for the court. So, and that also involves making sure your discovery is complete. Making sure you have your complete discovery and that you've turned over complete discovery to the other side. And discovery includes, whatever documents, um, uh, like physical things, notice to admit, interrogatories, even depositions. That's all what's included in the discovery phase. So in the pretrial portion of your custody hearing, you want to make sure you have all of that and you've provided all of that so that there's no issues when the trial actually comes. Subpoenas too. I forgot about subpoenas. Yes. The discovery phase usually starts way before, but if you know you're going to trial, then you want to make sure the discovery requests that you sent out were responded to and vice versa. So that is a very important part of pretrial. Also is your witnesses, your witness list. The court's going to want to know, and the other side too, who you plan to call as a witness. So you need to exchange that as well. Um, and you need to create a pretrial memo. A pretrial memo is very, very useful. It helps to summarize the arguments you're going to make, the points you want to stress, um, and it also serves to keep you on track with, those things that I mentioned, the discovery, the witness list, and all that stuff, because it's included in your memo. The pretrial memo is something that the courts usually require that you complete as well, and you turn over to the court. Some places require you to exchange it with the other side as well, but that depends on your jurisdiction. And the pretrial memo is just as important as the financial disclosure. Again, financial disclosures are something that's usually required in a divorce trial. But if your custody case or trial is part of a divorce trial, yes, you have to provide an updated financial disclosure with the W-2s, pay stubs, tax returns, all that stuff. It has to be updated. And I say updated is because a lot of times a divorce may start in 2019 or 2018 and not be resolved until or not go to trial until 2023. And so when you turn over the initial financial disclosure affidavit form, whatever they call it, and wherever you live, that was 3, 4, 5, 6 years ago, and things have changed. So you need to make sure it's updated. I'm trying to think of anything else that you would want to make sure of in the pretrial phase. I think that is it. Oh, one important thing too is during the pretrial, you want to get as much information about the court's procedure. Even though jurisdictions have their own jurisdictional rules, judges are also particular about the way certain things are done or handled as well. So during that pretrial phase, when you know the case is going to trial and you're at that point where you're preparing, take a trip or trips, to the courthouse and talk to the judge's clerk, secretary, whomever you can. Sit in if you can on other custody trials or hearings for that particular judge so that you can see how he or she prefers things be handled. And that will save you so much time and so much headache if you do that during the pretrial. Not wait to the day of trial or the day before trial to find out how to mark exhibits, or, if the judge prefers you to allows you to sit, or do they prefer you to stand, or, et cetera, et cetera. The sooner you actually do that, the better off you'll actually be, because you won't have to fumble. You won't have to waste the court's time and possibly piss the judge off. Excuse my language, but I don't think that's a bad word, but some people do. Piss the judge off by doing things, that are completely antithetical to how he or she is used to doing them. So do that as early as possible. I think that's so important. Not just for pro se, but for lawyers too. If a lawyer's in a new venue or new jurisdiction or a new judge. I know when I was practicing, I would like to know the judge's routine, the judge's idiosyncrasies, the judge's the way the judge prefers to do things, so on and so forth. So anyway, and then there's trial. Okay, so when you know your date for trial, um, and usually when you get a date for trial, it's usually set in stone, unless the court has a reason to adjourn it, or either party has a legitimate reason to seek a continuance. But being granted a continuance will depend on several factors. One, your judge. Two, the court's calendar. A lot of courts have what do they call it? I think they call it like target dates, where they want certain cases tried within a certain amount of time. So that'll determine if a continuance will be granted, um, and the reason, and how many continuances were granted previously. So, and the lawyers, the lawyer for the other side, or the GAL, their familiarity or their frequency within that particular courtroom with that particular judge may have an influence as well. But if you're pro se and you're the one that needs a continuance, you need to have a legitimate reason. You need to be able to document it, and you need to not use the other side as a reason why it should or should not be granted. You can always contact the other side first to discuss it with them and see if they will, work with you in seeking a continuance from the court, or you can go right to the court and ask the court for a continuance. If I were you, I would look at the track record of the case to determine whether or not that would be something you would actually want to put out there. So anyway, once you have done the pretrial conference, settlement conference, or whatever it's called, you will get a court date, right? So, and how far out in advance that court date will be, again, that varies from jurisdiction to jurisdiction. Um, Especially now with COVID, a lot of places are still doing trials by Zoom, which is crazy. It's crazy, but I guess it works. It's working because some places are still doing them. But yeah, know that too. You make sure your internet connection is working properly, your PC or whatever you're going to use. Make sure you have, uh, um, the call in or the dial in number ahead of time. Make sure all of that. Someone mentioned to me, I think in one of my groups, that was it in one of my groups? She missed a Zoom call because where she lives, the internet connection that day was horrible, and the judge didn't appreciate that. So the judge granted the other side, I think it was custody, on default. Yeah, the judge said that she defaulted, that she just basically didn't appear. Mind you, he knew she was on a call, but she would go in and out, and so I guess it rubbed the judge the wrong way, and he got really upset, and so he decided to, and it was a he, she said, he decided to enter a default against the custodial mom, and she lost custody. Now, that might be an appealable issue. I didn't delve deep enough to explore that, but anyway, so make sure that's not you. Make sure that doesn't happen to you. Okay. Um, so trial. I'm just going to run through trial really quickly because I don't want to be on here too long. So trial usually consists of an opening statement by both sides. Okay, and that's usually timed. Judges usually time you on that. Some of them don't even allow opening statements, especially in custody trials, because they think it's a waste. But you can ask for it anyway. You can ask if the judge says no, we don't do open. You can ask for it. If you insist on doing your opening, if you've been preparing and practicing and you're ready, you're gun ho, then you can ask for it. You can respectfully ask the court to oblige you. An opening statement is just to summarize what you're going to present, what the evidence is going to show. And again, both parties get to do their opening statements before the court. And it's usually in the order of petitioner and then defendant. Petitioner or plaintiff or defendant respondent goes next. So then you start calling witnesses. And when you call, both parties get to call their witnesses when their case is being presented. So as the plaintiff petitioner, your case is going to go first. So you're going to get to call the witnesses and your witnesses, and you will do a direct examination of your witnesses. And the other side, your opposing party, will get to do, of course, an examination of your witness, or they cannot. It depends. That totally depends. While the witness is on the stand, you'll want to, you may want to have exhibits introduced and verified and authenticated by your witnesses. And so that's at that point is when you present the exhibits to the witness. And again, though there are procedural rules on how you do that, which I will go into detail in my work in my 3-part series. But there's a way to do that, and each jurisdiction has their own way of doing that. So that was one of the things I was saying in pretrial that you would want to discuss with the court or the clerk ahead of time to get an idea of how that they want that done. When you're doing your direct of the witness, it's very helpful to have a list of questions. Work your questions out, get your questions out. Oh, one of the other things I forgot to mention is you had a pretrial memo. Now you have to have you should have a trial notebook. Your trial notebook should have every single thing in it that you think you need. And in my trial notebook, I usually have all pleadings. So that means if there are a petition for custody, and a cross petition, an amended petition, a response, an answer, motions, responses to motion, oppositions to motions, order to show causes. I usually have all of those. And then I have the orders. So every time the judge rendered a decision or order or ruling, I usually have a copy of those as well. One thing I often have in my trial notebook as well, which some people think it's a bit onerous, but for me, I like it. And for whatever reason, I always get prior transcripts. I always, and some of you are my founding members in my divorce blow up. You can attest to this. I'm always talking about getting transcripts. But yes, certainly for trial, I always order transcripts from previous court appearances because I study them. That's how I study the judge. That's how I get to know a judge, especially a judge that I don't know. I usually get my transcripts and I go through them to see how the judge what he has an affinity for, what he's not too what he doesn't take too kindly to. I like, and the lawyers too. If they're my opposing party, my opposing counsel, somebody that I don't know, usually my transcripts will tell me, help me, plot out who this person is so that I can plot my questions and I can present my evidence properly and I can gather evidence and pick witnesses and prep them properly. And it's everything for me is strategy. Everything from me is strategic. There's no part. Everything is a whole package. Everything serves a purpose for me. And it may not be something that I actually relegate to a particular part of the trial, but it serves some purpose for my trial prep, the way I handle the trial, et cetera, et cetera. So those should be in your trial book. Case law that you found that's relevant to your case, especially case law that's on point, that's specifically on point. On point means it's in your jurisdiction as your particular issue, and if it's the same judge too. Oh my God, that will be golden. But yeah, you should definitely have a case law. Statutes as well. The laws that pertain to your issues in your case, you should have a copy of that as well. And again, I'm going to go through all of this in detail. I'm just doing this as a brief overview because I just want to get some anticipation going. Also, always bring extra copies of things that you turned over or you provided to the other side previously. Bring extra copies for the court and for yourself and for the other side, just in case they say or something comes up preliminary. Sometimes before the trial actually starts, the judge gives both sides the opportunity to talk about some housekeeping issues. So you want to be prepared for that. And anything you had served, anything you had served and you have the affidavit of service, bring those as well. So I'll add to that list right now. That the other day I did that and that was what I came up with. So again, I'll add as things come up because that's how my brain operates. But anyway, so So I discuss opening statement, witnesses, cross and direct and cross, exhibits, questioning, and then there is closing, statements. I'm going to go through who you can call as a witness, what kind of exhibits you can introduce, what kind of questions you can ask. I'm going to go through all of that in detail in my workshop. Today, again, it's just an overview. I just wanted to give you a brief summary so that you can have an idea of what I'm going to talk about, and you can decide if it's something that you want to take part in. So anyway, the closing statement is usually something. It's like the opening, but it reiterates to the court what your case focused on, what you were able to prove, what the issues were, et cetera, et cetera, et cetera. Again, some some judges will waive openings, but they will allow closings, or some will do both. Again, if you insist on having one, respectfully ask the court to allow you to do both or whichever one you prefer. But it's okay to ask the court, even if the court insists on doing something unconventionally or untraditionally. It's okay to ask the court to give you the opportunity to follow the traditional rules and do things the way other judges do, especially in the same jurisdiction. So anyway, that is that. That workshop is going to be 3 parts. It's coming soon. I am going to do part 1 2 weeks from today. I'm going to get a little bit more in detail about these things. But I wanted to uh, give you a little teaser today. 2 weeks from today is what? May, I think 13th, right? I think so. Yes, May 13th. That's when I will do part 1 of the workshop. Part 2 and 3 will probably follow in the same time slot, a week from from the 13th for both consecutively. They won't be in the same day. They'll be a week apart. So, because I want to be as thorough as possible. So I want to give it some time and some thought. Anyway, so now I wanted to talk a little bit about what I actually do. I am a former family law attorney. I practiced family law for several years. I was a mediator, a guardian ad litem, a speaker, a writer, a blogger. Well, I still blog and I still speak. But now I just do consulting and strategy work. And that means you work one-on-one with me in several different capacities, different capacities as a coach, as a consultant, strategist, or you could just use unbundled services. That depends on exactly what you need. You can have a lawyer or not have a lawyer. What I provide is something that can benefit anybody at any stage of their case. It doesn't matter where you are, not geographically, because I only work with people here in the United States. But it doesn't matter where you are in your case, whether you're the plaintiff or the defendant, whether you're neither, and you're somebody who just wants to help. um, I can help you. I can do it hands-on, where you're going to court and I'm actually on call, where you're asking me questions while you're in court and you want some guidance on dealing with or navigating your way through a court hearing or court appearance. Or I can just consult with you. You can just call me as you need me and ask me, to give you a second opinion about something that your lawyer said or the other lawyer said or the judge said, clarity about something that's going on in your case. You can just run something by me, a mediation agreement, a settlement agreement. And then there's unbundled services where, I can just look at the settlement agreement. If you have one, I can just look at it and edit it and tell you and give it back to you and let you know what I think. Or I could prepare documents. I could prepare anything that is family law related. Doesn't matter which state you're in. I can prepare that according to your state's guidelines. I don't do it myself all the time. Sometimes I actually hire contract with other people in that state to do it for me. So it depends on what the item is. But I can do legal research or case law research. I can look up your judge, and so that you'll have an idea of how your judge typically rules in your particular case. I could do asset searches where I look up hidden assets. I work with private investigators for that, but I do background searches myself. I have access to databases where I can look up, do a background search for individuals. So those are the main things. But the most important message I wanted to and the strategic action plan. Now that's my baby. That's my favorite because that is the most intensive, customized, personalized preparation tool you could actually come up with for your case, because it's usually 10 to 20 pages long. And I usually, depending on where you are in your case, I usually look up the judge, your judge, the lawyer, the GALs, the laws, the statutes, the procedural rules, and I come up with a roadmap for you to help you get through, help you make decisions, make choices regarding the issues that are relevant in your case. That is my baby, because if I can't work with you one-on-one on a continuous basis, that is like a one-time thing I can do. It's a document that I prepare for you. It takes me hours to do it, as you can imagine. But it's something you can refer to through your case, unless things change. Things always change. But later on, at any point, you can amend it and ask me to do something further, or in addition to it, update it or whatever, based on new facts or new things that came to light. But the strategic action plan is the bomb. It is something, again, that's my baby. That's something that I take pride in, and I usually try to spend as much time and use every resource that's available to me to complete those. Sometimes I'm not as, I don't want to say successful, but I'm not as lucky or fortunate to get all the background that I want in a particular issue, or like a judge or a jurisdiction, because I can only use the resources that I have. And unfortunately, I'm trying to cover 50 states, and I haven't quite reached that far where I have a network in all 50 states, but I'm working on it. So anyway, that one is usually something, again, that I love to do. I love to help people with. And it's usually, something, like I said, no matter where you are in your case, no matter whether if you're represented or not, it's something that, you could use. You could use it with your lawyer. You could use it and not tell your lawyer. It doesn't matter. So anyway, you can find me on Facebook at The Divorce Solutionist. You can find me on Instagram at The Divorce Solutionist. You can find me on Twitter at the same handle, LinkedIn, the same handle, YouTube, the same handle. And guess what my website is? Yes, www.thedivorcesolutionist.com. The only thing that's different is my email. My email is divorcecoachesq@gmail. So you can always find me in any one of those, on any one of those platforms. And you can message me, say hi, message me and ask me a question, message me and let me know what you think about what I'm doing. I'd love to hear from you. I am always, well, most of the time, I'm available. I'm an airhead too, so sometimes I forget. So please just send me a little nudge to remind me that I said I was going to do something, and I'll do it. Because I'm always trying to help you, help yourself get the outcome you want. That is my motto. I try to give you everything you need to get the outcome you want and the outcome you deserve without going broke. So anyway, Facebook audience, YouTube audience, until next week, thank you for listening, for watching, and for being one of my followers and my audience. I appreciate you, and I look forward to working with each and every one of you soon. Bye.